All right, we're going to explore some important judicial philosophies. We're mostly going to focus on judicial activism and judicial restraint. There's a couple other kind of vocabulary things we want to talk about here and introduce a couple of different approaches, but mostly we're going to focus on the difference between judicial activism and judicial restraint. Here, we've got our friend William Rehnquist getting sworn in as Supreme Court Chief Justice there. There's President Reagan in the background on the right. Another justice that we've talked a lot about, Justice Antonin Scalia, way over there on the left. And this is as Rehnquist is taking over as Chief Justice of the court in the 1980s. All right, there's our friend Earl Warren. So this means it's time for us to talk about judicial activism. Now, when we're trying to explain this philosophy in words, what we mean here is that the judge, we're trying to talk about what does the judge think their proper role is. And in the case of judicial activism, the judge thinks that it's their job to change precedent if the existing precedent is unjust. They're not just changing precedent just because, but when they see a law or a policy that is unfair, they have the power to change it, and they should change it. So these judges are more likely to apply the Constitution and its ideas to more modern situations. So these are judges who would be more likely to describe the Constitution as a living document that adapts to the times that we live in. These judges are willing to make decisions that change policies. So when they see a policy that is bad, they feel that it's their job to correct that policy. So our most famous example of judicial activism would be Brown versus Board of Education. The policy, the law of the state, and the people, the state had been making laws about schools the whole time for more than 100 years. The law was the schools were segregated, and there was even a Supreme Court precedent because earlier they had decided in Plessy versus Ferguson that separate but equal facilities did that was what the 14th Amendment meant. So that separate but equal segregated facilities were allowed under the 14th Amendment. The Warren Court looks at that policy, says the policy is not fair, says that the interpretation of the court of the 14th Amendment is wrong, and they issue their decision in Brown versus Board that says you cannot have segregated schools, and that means they changed the policy with their decision. They changed the precedent that existed from Plessy versus Ferguson. So they threw out the old decision. They said that these laws passed by the states are wrong, and they told everybody what the policy should be so that schools must be desegregated. So they made a policy with their decision. That's judicial activism. The opposite of judicial activism would be judicial restraint. So there's our friend Warren Burger. He practices the philosophy that the judges who practice restraint feel like their job is to judge the existing law and to apply precedent, to interpret the law that was written by the lawmakers. So they see their role as a judge as not to make policy, but to follow and apply the policy that is made by policymakers. So they are going to strictly interpret the language of the Constitution and the existing law. They're not going to see the Constitution as a document that changes over time. They're going to interpret the words that are there. They think their job is to stay out of policymaking. If the policy needs to be changed, that's why we have policymakers in the legislature. So the role of the judges is only to apply the law that is there. So even if they disagree with the law, even if they disagree with the old precedent, they think, well, it's our job to follow the precedent that's there until someone changes the law. So in 1954, Linda Brown, she's suing the school board. She says that these segregated schools are unfair. If the judges in the court at that time were practicing judicial restraint, they would feel that they had to follow the existing precedent in Plessy versus Ferguson, separate but equal. They'd say, sorry, Linda Brown, we don't like segregated schools, but the law says separate but equal. If there's a white school and a black school, then you're getting equal treatment. So they would have followed the precedent in Plessy versus Ferguson. They would not have changed policy if they were practicing judicial restraint. So this is an opposite philosophy here, where the judges stay out of policy making. All right, stare decisis is, it's not separate than judicial restraint. It's along the same lines here. It's just a different vocabulary term that we're going to see. When we translate stare decisis into English, it really just means let the decision stand. And this is an attitude or an approach to judging that the earlier precedent, the existing earlier decision, should almost always hold for the case that's in front of them. So this means that the Supreme Court should almost always follow the previous precedent established, and that the Supreme Court is rarely going to overturn precedent. This is definitely the attitude taken by current Chief Justice John Roberts. He's very reluctant to change the precedents that exist in the courts in a lot of ways. That's been his recent approach here. So what this means is that the Supreme Court should give a whole lot of consideration to the existing case, the existing examples and precedents that were before them. So they're going to be less likely to overturn settled precedent. So they don't really have to rethink legal decisions. They don't really have to rethink new opinions for the court or anything. They're just going to follow the examples of the past. So stare decisis, let the decision stand. It means we're going to stick with the precedent that exists. All right, it's your friend Antonin Scalia. So that means we're going to talk about originalism. This is a philosophy most associated with him. This is not really separate than activism or restraint, but this was the philosophy he followed, and a lot of people since him have followed. And they say that they want to find the original meaning of the Constitution. So they think that the Constitution should be interpreted in a way that is consistent with what was meant by the people who drafted and who wrote and ratified the Constitution. So they think that we need to, when we're interpreting the Constitution, we've got to consider what was meant by those people writing the Constitution back in the 1780s. So what would the people at the time have realistically thought about things when it's time to decide things like what does the Second Amendment mean today? Scalia and originalists want to think about, well, what did the people mean when they wrote this 250 years ago? When they're trying to think about religion and speech limits and stuff, they're trying to consider what would the people who wrote the Constitution have thought, and they try to apply that to the decision today. And then here is Scalia's replacement on the court, Neil Gorsuch, who believes in, he's got a philosophy that's very similar, but a little different here. And again, not separate from activism or restraint, but this is what we call textualism. Some people may call this strict constructionism. And so what this means is that these judges are going to focus mostly on applying the text of the Constitution. So focus on the words as if they are written. So if they're deciding a case and you can clearly tell what the words say, then we don't have to think about philosophy on policy or think about what they meant or anything like that. That judges don't need to be trying to infer information. Everything they have is right there in front of them in the words of the Constitution or the words of the policy. So he really focuses on the words and applying the words when he's trying to make a decision. So this is one of our other judicial philosophies. There we go, guys. Not only did we finish the Supreme Court and all the things we're going to talk about with the Supreme Court, but we have finished all of Unit 2, a very, very long unit covering all the branches of policymakers in our national government here. So just like President Trump, it's time to sing and celebrate. Put on your party hat and celebrate the end of Unit 2. So let's take a look at our bigly ideas. All right, there's a lot packed into this one, so we want to make sure that we can explain how the Supreme Court's power expanded under the Marshall Court. We want to make sure that we can talk about how the role of the Supreme Court changed in the 1900s, go back to think about FDR and Truman, think about the Warren Court and the Burger Court. We want to think about the philosophies of those courts, and so those philosophies are important. We're definitely going to be asked about judicial activism and judicial restraint. So let's make sure that we can pay attention to how those judges feel. Do the judges think they should change bad policy? That's activism. Do the judges think they should stay out of policy making? That's restraint. And increasingly, we're seeing these other philosophies pop up. So we want to make sure we understand what originalism means and what textualism means and all that. Come on, Ben Carson. Give Trump a high five. All right, like we said, that is it for our Supreme Court history and philosophy here. We've learned a lot about how the court has changed over time, learned a lot about the different philosophies that judges might have, and that is also it for Unit 2. So we have gone through the judicial branch most recently here, learned all sorts of stuff about the judicial branch and its different levels. We've looked at the executive branch, not just the president, but the role of the bureaucracy and the civil service, all those street-level bureaucrats out there delivering services to hundreds of millions of Americans every day. And way back, we learned about Congress, our policy-making branch, legislating and making policies for the House of Representatives and the Senate, and making policies for the rest of the country. So we'll spend the next good bit of time reviewing all this stuff. This is going to be our biggest unit, not only in class, but also on the AP exam. So everything will come back to what we've learned here in this unit.